Hi, my name is Maria Annerly, and today I'm going to be discussing Elonis versus the United States, a case of alleged cyberstalking that made its way eventually up to the Supreme Court. In 2010, a man named Anthony Elonis posted many videos of his own self-created rap songs with very graphic lyrics to Facebook, which is arguably a very public platform. But these videos had very graphic lyrics describing things that he wanted to do and ways that he wanted to harm very easily identifiable parties, specifically his ex-wife, his current co-workers, an unspecified kindergarten class, as well as law enforcement officers, both state and federal. So he threatens specifically the local police as well as an FBI agent. And in these videos, it was posted to say that this wasn't a threat, but the lyrics still caused a lot of harm and people started reporting him. Actually, he worked at an amusement park, and his boss, who was friends with him on Facebook, saw the videos and then fired him, as well as reported those to the FBI, who began to monitor his posts. Eventually, they determined that they could charge him under federal law, and specifically under the statute that says whoever transmits an interstate or foreign commerce or any communication containing any threat to kidnap any person or any threat to injure the person of another shall be fined under this title or imprisoned not more than 5 years or both. So he was charged for 5 accounts, one for each threatened party, the ex-wife, the co-workers, the kindergarten class, as well as the law enforcement officers. The lower court decided to uphold the conviction for 4 out of the 5 counts and sentenced him to some time in prison, as well as probation afterwards and supervision. He appealed his case, and it went to the U.S. Court of Appeals for the Third Circuit, who also appealed the district court's decision, or affirmed the district court's decision, and upheld that conviction. However, his lawyer and he was still not pleased with that decision and decided to appeal it once again and give a writ of certiorari to the Supreme Court of the United States. So his rationale for the appeal and basically the defining factors for this entire case, especially when it comes to cyber stalking cases, is the definition of a true threat. So under the First Amendment, you have protection for your speech, but what's unprotected is things that threaten another person directly. So the argument in this was that he never directly threatened any of the parties that he was charged with threatening, and it was what determines the basis for that true threat. So what's the level of scrutiny that must be applied? And he argued that there must be some kind of subjective intent required to fulfill the mens rea of this act. So a criminal act has to contain a mens rea and an actus reus. So the actus reus is the actual action that is being done, which is the harmful content that he posted. However, he's saying that there is no mens rea. There is no intent to actually threaten these people. And he also posted disclaimers with the videos. In court he brought up examples of other artists who have done such things and posted it to YouTube. But the lower courts continue to uphold the reasonable person standard, saying it doesn't matter what the intent was. If any given person, your average person off the street, looks at the content and determines that this constitutes a threat, as an objective standard, then that's enough to go forward with the conviction. The Supreme Court reversed the lower court's decisions 8-1. Seven justices affirming the majority decision, with one person who was partially agreeing and partially dissenting, and then there was one dissenting opinion. But they applied the negligence standard, or they determined that the lower courts applied that, which is that objective, reasonable person standard. However, they decided that for this particular statute, you have to use a subjective standard. They determined that the federal government failed to satisfy that mens rea. So, because their entire argument in the lower courts was that it didn't matter what his intent was, which is inconsistent with most criminal law. So in arguing that it only mattered what the actual words and the content of the videos were, they were completely ignoring the intent, which is very important when it comes to matters of freedom of expression, specifically in online contexts, which are usually generally considered a public environment. So some of the big takeaways and the relevance of this case are the presence of the threats as part of a digital environment and the fact that in that public environment it's really difficult to prove intent. So prosecutors have succeeded and gotten their cases through courts using the context and the circumstances of the case to prove intent, but that's very difficult to do. The Supreme Court really avoided discussing recklessness. So, in establishing that there had to be intent, they didn't really address the potential for extreme recklessness or extreme negligence to be used as a method of claiming intent. So they just kind of avoided that entirely. They used the all inclusive approach, which is very typical of the Supreme Court, looking at specific classes of things, such as true threats, as unprotected by the First Amendment, but then in determining the level of scrutiny and standards for what constitutes a true threat is extremely difficult, especially in online platforms, because there's various levels of direct and indirect communication. So you can, directly message someone, but you can also post something on a platform that directly pertains to someone else, but it still takes place in a very public environment. That's the difference between in the physical environment, walking up to someone's house and talking to them on their private property, as opposed to saying the same thing from the sidewalk outside their house. So a lot of the lower courts are now starting to use a democratic self-governance model. So they determine what level of scrutiny to apply by the presence of publicly relevant ideas. So in using that model, instead the Supreme Court could have looked at his content and said, is anything that he said here relevant to preserving freedom of expression? So, threatening a kindergarten class, threatening his ex-wife, that doesn't have to do anything with politics, religion, or anything that is relevant to the general public. So then it wouldn't necessarily be applied the same scrutiny to the case as other things like under the First Amendment. If he was insulting his ex-wife on the basis of her religious beliefs. That is a very different case. So, it's still evolving what the Supreme Courts and the district courts have to say about cases such as cyberstalking, where the content can be taken very personally, but it exists in a public environment like Facebook. But this is one key case where they kind of skirted a lot of the questions that have been posed in order to allow room for more cases to make their way through the lower courts and evolve their flexibility in what the public and the private responsibility for protection of speech and protection of victims from cyberstalking are. Thank you very much for listening.